First, let's update you on this. The defense is expected to continue grilling Tumelo Madlala in the Senzo Meyiwa murder trial. The former Bafana captain's best friend is the state's third witness. While Tumelo Madlala was in the house when Meyiwa was shot back in 2014. eNCA reporter Slindelo Masikane is currently following those developments and this case closely for us and joins us now for the very latest. Lee, good morning to you once again. Let's bring in some context. A lot that Tumelo Madlala had to say just in terms of what he witnessed on that fateful day where Senzo Meyiwa met his untimely death.
More details coming out here in the North Gauteng High Court. We are, of course, expecting cross-examination of Tumelo Madlala to resume at 10 a.m. this morning. But yesterday's proceedings quite explosive and dramatic. We began with a surprise visitor, of course, Advocate Malisa Latefo, who's due in this court, in fact, for a verdict on an application by the LPC to have him struck off the roll and disbarred. But at the same time, while he was escorted out of court, proceedings then resumed with the state then asking Tumelo Madlala to point out as to which of the 5 suspects he recognizes as one of the alleged intruders. That was one of the dramatic moments where he then pointed to accused number 2, Bongani Ndanzi, who's also due for an urgent bail application next week. He's the only one out of the 5 men who actually has no previous convictions. But to unpack the proceedings yesterday, I am joined by legal expert, that is Mr. Marius du Toit. Thank you once more for your time this morning. Let's just begin with that doc identification by the state. Just how significant is it, or how much weight can the court actually put on it?
Not much, Lee. I think the difficulty you have is when you deal with a doc identification, it has the same effect as a leading witness, because who else is he going to point? Somebody in the gallery? Is he maybe going to point to the prosecutor to say he was there? I mean, the only people that he could point is the people in the doc itself. So typically speaking, on the last occasion when we spoke, we discussed the issues when it comes to identity, because there's certain things that the state has to do in order to get an identity of the accused proved beyond a reasonable doubt. And one of them would be, number 1, if I know the accused, then of course I can say, Slee, listen, I've seen you every day, I know you very well, you're absolutely the person that I pointed. However, when I've never seen you before, I only saw you at the time of the crime, then of course an ID parade ought to have been held. And if an ID parade had been held and I wasn't able to point anybody, or if an ID parade was held and I was able to point a person, well then of course the probative value of that it really moves up an echelon or 2. So at the end of the day, if it's purely a doc identification with no basis why this identification is made, really little weight can be attached to it. Like I said, the courts have often said a doc ID should actually be inadmissible because it has the same effect as a leading question. And a leading question normally suggests the answer, and that's why it's inadmissible. So in this instance, unless there was a basis by the state, unless they were saying, listen, we did an ID parade, we did a photo ID parade, or we did a physical ID parade, or at least I knew the suspect, I don't think it carries much weight.
Let's unpack the cross-examination that's just begun by TT Tobane for accused 124. Of course, accused number 2 being one of those that he represents. 4 of those men are actually his clients, so I think he's got quite a huge task on him. One of his clients now being identified, but now he is trying to poke holes, of course, in Madlala's story, also posing the scenario in the second docket to him. He's also picked up some inconsistencies in terms of what he said in his testimony and what's in his statements. What inferences can the court then make of this?
So when the court evaluates the evidence of a witness, there's a number of things that the court look at. Number 1, the court would look at previous inconsistent statements, and those can be oral statements made to a third party. It can be written statements. It can be contained in the statements of other witnesses that say, well, Marius was never at the scene, and how can he now say he was at the scene? And it could, of course, be that I'm be confronted with forensic evidence or ballistic evidence. So there's quite a lot of evidence that the state or that the defense have in their armory to confront the witness with. Now, it is never advisable to have 4 statements by a witness, because the more statements the witness make, the bigger the chance that the witness will contradict himself or that he'll make a mistake. Now, of course, you can always see your previous statement. It's not like you do a second and a third statement coldly without seeing your previous statements. But having said that, Slee, it is not advisable, especially if you contradict your previous statements. That's actually, to be honest with you, just sloppy. I mean, if I make 3 statements and they are materially contradicting one another, essentially what I've done, because remember, all statements are made under oath. So essentially, if I'm deviating from my previous statements, I'm lying under oath. I'm stating as a fact, I swear to God, that this affidavit is the truth. Now I say something completely different. So it immediately affects the credibility of the witness. It immediately affects the conclusions that the court will draw and the weight of the witness. So if you want to shoot yourself in the foot, you would make 4 statements that are contradictory to one another. You contradict the forensic evidence, well, then it's going to be quite easy for the court to say, well, listen, I can't attach much weight to this witness. This witness was so poor, I reject this evidence outright.
Just quickly then, Mr. du Toit, do you foresee the state having to call someone else in the House to possibly corroborate Tumelo Madlala's version of events?
Absolutely. I mean, the state would not call 5 witnesses about the same thing, because then it just gives the opportunity of having more contradictions. But at least 2 witnesses that sort of corroborate one another would definitely be crucial for the state, because the court at the end of the day would look for that golden thread running through all the evidence pointing to one of the accused. So at the end of the day, I think that's definitely what they might want to do. The question is just whether they have such a witness, whether this witness can truly corroborate what Madlala says, and whether in fact it's going to, at the end of the day, be sufficient to say to the court, well, I can convict these people. So the time will tell, but it's not easy for the state, it seems.
Thank you so much for your time this morning. That is legal expert Mr. Marius du Toit, just unpacking yesterday's proceedings for us. Of course, we look forward now to 10 o'clock when that cross-examination for Tumelo Madlala then continues. And of course, we will be bringing you those visuals live when they begin. Back to you.